Good morning, everyone, and welcome to this live webinar being put on by the Independent Jewish Voices of Canada. My name is Rafi Silver, and I'm going to introduce IJV to those of you watching it, and then turn it over to our moderator. So for those of you who are unfamiliar with Independent Jewish Voices, we are a national Jewish organization with chapters across the country. We're a grassroots organization grounded in the Jewish tradition that opposes all forms of racism and injustice. We are strong advocates for peace in Israel, Palestine, and about 10 years ago, we became the first national Jewish organization in Canada to officially support the BDS, or Boycott, Divest, and Sanction movement against Israel, a point that we're very proud of. And we've been working on the BDS campaign with our partners in Palestine and around the world ever since. We encourage everyone to check out our website. It's www.ijvcanada.org. If you want to sign up for our newsletter, you'll be able to do that on the website, as well as if you would like to make any donation, it's ijvcanada.org/donate. So what I'd like to do now is I'd like to introduce our moderator for today's event. It's Dimitri Lascaris. Dimitri is a lawyer, a journalist, and activist, a longtime supporter of IJV. He has served on numerous boards of directors of nonprofit and public interest groups, such as the Real News Network, the Unity Project for the Relief of Homelessness, Pro Bono Ontario, and Toronto 350. And Dimitri is a leading member of the Green Party of Canada. So thank you very much, by the way, Dimitri, for your willingness to moderate this event. And I'd like to turn it over to you.
Thank you, Rafa. It's a pleasure to be here. First of all, I would like to acknowledge that I'm coming to you this morning from, and as is Rafa, from the unceded territory of the Kanien'kehá:ka people in what is now known as Montreal. And we are privileged to live and work on this land of which they are the true custodians. I also want to just say that, it's absolutely correct. I've been a supporter of IJV for many years. It's an honor and a privilege to work with the fine citizens and comrades and allies from Independent Jewish Voices Canada. One of the best experiences I've had of many working with IJV has been a piece of litigation in which IJV has been played a very important role, involving the importation of wines produced in Israel's illegal West Bank settlements. Those wines have long been labeled as product of Israel, and a friend of mine, a member of IJV, Dr. David Kattenberg, took it upon himself to challenge the labeling of these wines before the Canadian Food Inspection Agency. Initially, he persuaded them that the wines were falsely labeled. The agency came under intense political pressure and reversed itself in less than 24 hours. And that pressure included pressure from the ambassador to Canada of the State of Israel. And then on behalf of David, I launched a judicial review application in the federal court of Canada. And last year we persuaded a judge of the federal court, who had been the president of the Canadian Human Rights Tribunal prior to becoming a judge, that the CFIA had made the wrong decision. And in fact, the labels were false, misleading, and deceptive. And now we're up in front of the Federal Court of Appeal. The role that IJV played, really, again, one of the many wonderful things it's done was it intervened in that litigation with a great lawyer by the name of Barb Jackman, and persuaded the court that the charter right, the right under our Constitution to free speech, was impacted by the decision, because depriving Canadian consumers of all the facts they needed to engage in conscientious shopping was a way of impeding the exercise of conscience and free speech on their behalf. So we're hopeful that we'll succeed at the Federal Court of Appeal, but we'll see. And whatever happens, it's been tremendous working with IJV. So with that, I'd like to introduce our guest, Sawsan Zaher. She is the Director of Social, Economic, and Cultural Rights Unit at the Adalah Legal Center for Arab Minority Rights in Israel, which does fantastic work. And if you're not familiar with Adalah, I do urge you to consult its websites and many of the wonderful reports it's produced. Sawsan is a Palestinian citizen of Israel, a feminist and a human rights lawyer currently with Adalah. And she's, through her work with Adalah, Sawsan has litigated several landmark cases before the Israeli Supreme Court, challenging discrimination and racism against the Palestinian minority in Israel. She's received several fellowships and honors, including being selected as a 2015 Young Global Leader, an integral part of the World Economic Forum, a 2012 Fellow at the Women in Public Service Project at Wellesley College, and a 2008 Fellow of the Public Law Program in the Public Interest Law Institute at Columbia University. In January 2015, Sawsan was appointed to serve as the Acting General Director of the Women's Center for Legal Aid and Counseling in Ramallah, Palestine. It's an honor to have you here today, Sawsan, and I understand you're going to be talking to us about discriminatory laws and systemic racism in Israel. And before I turn it over to you, I just want to say that when Sawsan is done, there will be ample opportunity for members of our audience to ask Sawsan questions. And you can just type your questions at the conclusion of her presentation in the Q&A. So with that, I turn it over to you, Sawsan.
Thank you, Rafi. Thank you, Dimitri. And thanks everyone who is attending and taking from their time. I'm happy to be here today. And I think that today is to be with you now these days is very unique because soon on December 22nd, we are going to be arguing before the Israeli Supreme Court in one of the most important petitions that relate not only to Palestinian citizens inside of Israel, but to also Palestinians in the occupied territories, challenging the constitutionality of a recent basic law called the Jewish Nation State Law, which I will, of course, address during my presentation. Adalah, the Legal Center for Arab Minority Rights, for those who don't know, is a non-governmental organization that was established in 1996. Throughout the last 25 years that we have been active, we became the leading human rights organization on behalf, litigating on behalf of Palestinians, whether inside the borders of Israel in 1948 or on behalf of the rights of Palestinians in the West Bank and Gaza. Adalah has three main departments. The first and main department, which does the core work of Adalah, is the legal department. And we do litigation in all fields of rights, whether it is land and planning, social and economic and cultural rights, and whether also it's political and civil rights. The legal work that we do, we also base it in our international advocacy work. We do advocacy work before the UN. We have an independent ECOSOC status before the UN, which enables us to submit what we call shadow reports for the different UN treaty committees in order to basically report on violations of Israel's obligation to the UN on treaties that it had signed and ratified. We also do advocacy before the EU. And we also have the third main department is the media department, where we work in three languages, Arabic, English, and Hebrew. And we try to reach local, regional, and of course, international media. Now, it's very hard to come and talk about one specific issue when we want to address the discriminatory laws or the legal status of the Palestinian citizens inside of Israel, because it needs also a historic background and what has been happening in the 2000 onwards after the second Intifada, and what's happening now, especially after the enactment of the basic law, the Jewish Nation State Law. But it's still important to address that after the establishment of the state of Israel, after the Nakba, which we call the catastrophe, where 80% at least of the Palestinians became refugees all over the world. An average of 20% were able to stay in what became the state of Israel. And in order to determine the rights of this population that was able to stay, there were few laws, if we'll of course focus on the legal system, there were few laws that focused in the areas of demography and land, which enabled the strengthening of the basis of Israel as a Jewish state, excluding the Palestinians who became citizens of Israel. These laws, first of all, prohibited the return of Palestinian refugees to what became the State of Israel. However, it enacted or it enabled automatic return to the Jews from all over the diaspora, entitling them with automatic citizenship the moment that they enter the borders of Israel. Which says a lot. This means that demographically, there will be no more Palestinians coming in, but more and more Jews coming in. So the law of return, which enabled this, was as well enacted as one of the most important laws in order to balance the demography after the end of the war. And it is still one of the most dangerous and important laws because until today, it basically specifies the classification of citizens between those who are Jews and those who Israel calls non-Jews, which basically are the Palestinians. The other set of laws are laws of land, which basically prohibited the return of property, whether it's land or other kinds of property, to their owners, to their Palestinian owners. This basically enabled the shutdown of a lot of Palestinians' institutions and homes and houses and buildings in a way that did not enable and permit the return of Palestinians even to enter the buildings themselves and demand the return of their property. Other sets of law related to citizenship, which basically also put a lot of boundaries and restrictions on who can be defined as a citizen in a way that excluded the Palestinians who were able to stay in Palestine, what became the State of Israel. Why I'm saying that? I'm saying that because the new State of Israel back then saw two main elements as the basis of the start of the Jewish state. If we have enough land, then we can keep the physical existence of the State of Israel. And that was the reason for the different set of laws in property. And if we keep a majority of Jewish demography, Jewish population in this territory, then we will also be able to preserve the Jewish majority in the State of Israel. And since then until today, Israel has been defining itself also on a constitutional level as a Jewish and democratic state. Of course, we all know that these two elements cannot live together because you cannot preserve democracy in which the right to equality and the principle to equality is one of its most important constitutional values and rights. And on the other hand, say it's a Jewish state for one ethnic group, which is the majority group, and in this way exclude constitutionally all the rest of the groups, considering the fact that Palestinians are not any other group of citizens and they are not an immigration minority, they are a homeland native minority. Now, so this brings me to what has been happening in the last 15 years. A lot has been said about the year 2000 onwards, and I will certainly like now explain to what I mean, that there has been a lot of discriminatory laws that targeted Palestinian citizens of Israel and made them a second-class or even a third-class citizen. This is true, but the background that I gave was important in order to know that there is a systematic legal system that aimed from day one to make classification and citizenship between the Arabs and the Jews, which enabled throughout the years systematic discrimination in all fields of life, whether it's the allocation of property, if during the Nakba or before the Nakba, 93% or even more of the land was within private ownership of Palestinians. Today, 93% of this land is within the ownership of the State of Israel. It also enabled that systematic discrimination and budget allocations, even without a need for a law. Throughout all these years, the budget allocation in education, in health, in welfare, and in allocation for local authorities has been viewing a lot of disparities based on the fact that the state have been wanting to give more intentionally to the Jews on individual and collective level, and less to Palestinians, whether on individual or collective. Collective, I mean local councils, not individuals. But in 2000, after the second Intifada, which was in 2000, we started to see that the policies started to be passed as laws through the legislator. And one of the first dangerous laws that we viewed was in 2003. And it's not a coincidence because it was at the same time, it was passed at the same time that the separation wall was built was built, of course, by Israel on West Bank, Palestinian West Bank land, in order to provide a physical barrier between Israel and Palestine, or the Palestinian territories in Israel's eye, so that it will not allow the entry of Palestinians into Israel. Now, at the same time of building that wall, which was also challenged not only before the Supreme Court, but also was challenged before the International Court of Justice, the ICJ, which ruled that this wall is in violation of Israel's obligation towards Palestinians based on international humanitarian law. But at the same time, Israel as well passed another law that affected directly the Palestinian citizens, which was the family unification law. This law came and said, Palestinians from the West Bank and Gaza are not allowed to enter Israel for the purpose of family unification. Now, it was the years of suicide bombers. And this law allegedly came in order to deal with that phenomena of the second Intifada. But while challenging that in court, Adalah, of course, was the leading organization that challenged that before court. We understood that permits to enter Israel for the purpose of work was still enabled. Other kind of permits were still enabled. And when we asked the state before the court, okay, you want to challenge suicide bombers, you want to challenge the fact that you don't want Palestinians to enter and commit any kind of attacks inside of Israel. Okay, show me what is the number. If we're talking about hundreds or thousands, we can understand and we can formulate our argument in court accordingly. But the result of our questions before the court resulted in 2006 by the fact that there were 0 indictments submitted against Palestinians who were able to enter through the process of family unification, knowing that in the decade before, 10 years before the law, there were almost 195,000 applications to allow the entry of Palestinians inside of Israel for the purpose of family unification. So it was very clear that the purpose of the law was not security, but it was demography. It was the attempt to control the number of Palestinians who would enter Israel, live, establish their life, and continue, of course, expanding their family inside of Israel, which was a clear threat to the demographic stability and the balance that Israel was trying to keep all the time. Now, of course, that was in our eyes as a human rights organization, one of the first dangerous laws in a series of other laws that later on were passed. Why the most dangerous? Because it was the law that started to view Palestinians as a threat, as an enemy, as a group. Now, of course, we were all the time seen as enemy, but this time there's a law that gave legitimacy by the legislator that viewed all the group of Palestinians, provided a sweeping, basically ban with a sweeping perception of being an enemy, being a threat, without even considering to have individual check for people who really, which is the 99% of the people, who really wanted to merely basically just live with their own spouses. And until today, it has been, it's affecting thousands, the lives of thousands of families, thousands of spouses who are until today living under the daily threat of being separated from their parents, from their spouses, from their children, and just because of demographic threat. Of course, if I want to make an analogy, this law clearly resembles similar laws during World War II, where Germans who fled to Britain, fleeing the Nazis, were all being viewed as enemy, and their freedom and liberties were restricted as a group without an individual check. It was also been applied on Americans from Japanese descent, where we also know that more than 100,000 Americans from Japanese descent were interned in camps during World War II by the American government. This law also was justified, and we lost in the Supreme Court. It was justified in a very dangerous, racist, illegal narrative by the Supreme Court, and later on allowed a series of other discriminatory laws, like the law that basically sanctioned those who called for boycott, which was a kind of mentioned by Dimitri before. It sanctioned people who called for boycotting Israel. Another law, which we also, Adalah, also challenged in the Supreme Court, and we lost, of course, for political reasons. Another law that was passed was the admission committees laws, which is basically an admission committee that sits in community towns, and they do interviews for family who submit application to get accepted to live in that community town. And it provided the ability or the justification for the admission committee to basically refuse application based on cultural and social incompatibility of the specific family to the community town, which basically was meant in order to refuse Palestinian families that wanted to apply for to live in community towns. We also in Adalah challenged the law, and we lost in the Supreme Court. Another law was also sanctioning funded organization, a government-funded organization, who wanted to do events to commemorate the Nakba on May 15. Now, the Nakba is a part of our political, historic, collective narrative, which basically is the catastrophe that happened to us as Palestinians in 1947 until 1948, which led to the fact that there was no more Palestine, and 80% of the Palestinians became refugees until today. And the mere fact that a state-funded organization used the funding in order to do commemoration was sanctioned to up to more than 3 times the fund that they would get from the state. Adalah also challenged this law, and not surprisingly, we lost in the Supreme Court. And of course, I'm not talking about other systematic policies that also relate to the fact that in the south part of Israel, where the Bedouins, who are Palestinian citizens also of Israel, live in the south part of Israel in an area called Naqab in Arabic, or Negev in Hebrew and in English. And in that area, the Israel until today refuses to recognize more than 35 Bedouin villages, which basically results in refusal to connect them to electricity, to full educational services, to water, to internet, and so on and so on. And Adalah has also, throughout our work, been challenging the refusal not only for the recognition of the villages, which basically is villages that, like, we're talking about land and property owned for decades before the state of Israel by private Bedouin Palestinian owners. Of course, you can imagine, like here, like in Canada, or like in other places, that the dispute is not about where to recognize or not, but it's about no recognition in order to take the land out of Palestinian Bedouin hands and establish new Jewish towns, which is what is happening in the Naqab. Now, until July 2018, I would have said that, thank you, this is my presentation. And of course, would invite you to our website to see more about our work in order to convince you about the plight situation of the Palestinian rights. But in July 2018, another dangerous thing happened, which is the passage of the Jewish nation state basic law. Now, in Israel, there is no written constitution, but there are basic laws that are considered by the Supreme Court of Israel of having a constitutional status. Every basic law is a chapter of the future constitution of Israel. And this basic law was called the Jewish nation state law. And I think it's enough to read its article in order to come and say that all what I had said before is basically, I could have summed it up with the articles of this law, because it comes and says, for example, in Article 1, it leaves the borders of Israel open, of course, in order to enable the expansion of the border of Israel to all the Eretz Israel, to all the land of Israel, the historic biblical land of Israel, from the Jordan River to the Mediterranean. And it also says in Article 1 that the state of Israel was established for the Jewish people as a home for the Jewish people, and it provides it an exclusive right for self-determination. Now, this has a lot of implication. This is basically a constitution that sets for the first time the constitutional identity of the state of Israel, belonging based on ethnic superiority and supremacy for the Jewish people alone, especially when it states that the right to self-determination is provided exclusively to the Jewish people, which basically means that there is no ability within the state of Israel for Palestinians to claim self-determination. I'm not talking about only the right to establish a state. This is the classic meaning of self-determination in international law. Self-determination has been developed in international law to include the ability of every individual and every person to determine its own destiny, which basically is related to fulfilling basic needs in all levels of lives. So this constitutional identity basically enables and gives constitutional legitimacy for all kind of discrimination. If until today, I, as a lawyer in Adalah and all other lawyers in Adalah, were able to go to the Supreme Court and argue for canceling laws or canceling discriminatory policies based on the constitutional right of equality. Now, this law basically imposes a huge question on my ability on the fact on what the state or attorney general will as well respond to all of our arguments, because he will be able to come and say, Article 1 of the Jewish nation state law enables and gives exclusivity for the Jewish people to determine who owns land, who gets more budget, who gets more exclusive towns for themselves. And I'm not saying that out of the blue, because Article 7 of that Jewish nation state law enables the establishment of Jewish-only towns, giving them priority to also be based as towns. And Article 4 of this basic law diminishes the status of the Arabic language and says that the Hebrew language is the only official language in the state of Israel. Now, of course, we can talk a lot and analyze a lot. I'm not going to take a lot more of your time in order to keep time for questions and answers. But it's important for us to say that even if the system since 1948 until the Jewish nation state law was built on systematic racism, and yes, there were other discriminatory laws before, the danger of having this being anchored, this perception and conception of supremacy and superiority for the majority group in a constitution gives a constitutional legitimacy for discrimination and for other dangerous issues that maybe we cannot anticipate in these days. Adalah has, as I mentioned, challenged this basic law, this constitution, before the Israeli Supreme Court. And just a few days ago, the Attorney General of the State of Israel submitted its 120 pages response in a narrative basically that goes back to the Zionist conference in the late 1800s, to the Balfour, and then to the partition plan, and onwards with the justification of how Israel is the state of the Jewish people, which basically means that there is not only classification of citizenship in a constitution, which, by the way, doesn't exist in any democratic constitution in the world. There is no constitution today in any country that regards itself as democracy, which gives supremacy to one ethnic group. The last one was the Constitution of South Africa apartheid, which was abolished, as we all know. And today there is no other constitution in the world except this one. Now, before I headed to Q's and A's in order to give the participants the ability to think about it, I would also like to invite you to use my hat as a Deputy General Director of Adalah and invite all of you to get into our website and donate and support Adalah. Our work has been extraordinarily important to defend and promote and protect the rights of Palestinians in all fields. We have also been working tremendously intense also during COVID-19, where the results and impact of the systematic discrimination also were felt regarding the disparities in services, whether it is providing Like for every little thing, we had to petition to the Supreme Court. And of course, we had good results, whether it's to ensure distance learning for Palestinian children in the unrecognized villages, whether it's to provide Corona drive-in test in East Jerusalem or in the unrecognized villages, and so on. Our website has rich information, and I will also send on the chat now the page for donation for those who would like to support us as well. So thanks a lot, Dimitri, and I'm ready for Q's and A's.
Thank you, Sawsan. That was fascinating. And I'm going to start the ball rolling by asking you a question myself, because as a lawyer, one who has spent a significant amount of time litigating Palestinian rights issues in Canada, I was fascinated to hear about your experiences at the Israeli Supreme Court. And the background of my question is that there has recently been a controversy at the University of Toronto, which is where I attended law school, surrounding the hiring of an academic, or the proposed hiring of an academic who had some history of being critical in her scholarship about Israel's treatment of Palestinians. And it's alleged that the dean of the University of Toronto Law School became involved in preventing her from being offered a position at the university. This has created a lot of controversy. This same law school established a distinguished law fellowship in 2006 for Aharon Barak, the former president of the Israeli Supreme Court. And just reading the press release of my alma mater when it announced this distinguished fellowship, I mean, really talks about Aharon Barak's work on the Supreme Court as an extraordinary defense of human rights. Says his most controversial decision was his determination that the basic laws protecting fundamental human rights would have the status of supreme law, rendering invalid any inconsistent Knesset legislation. My question to you is, in the Western world, the Israeli Supreme Court is generally regarded, certainly in the mainstream media, as a truly principled and rule of law oriented judicial institution that deserves the full respect of jurists around the world. And I'd like you to comment on just overall on your experiences litigating before the Israeli Supreme Court. How protective do you think it actually has been in practice of the most basic concepts of human rights as applied to Israel's Palestinian minority?
Yeah, that's a great question, and the answer will be very long, but I will try to basically tell you that Aaron Barak is a very clever man, and of course he's one of the most well-known judges internationally, and his decisions would have, with regards to Palestinian citizens in Israel or in the occupied territories, would have a very liberal narrative for the analysis, but all the time based on the legal interpretation or the constitutional interpretation, in most of the times, especially regarding West Bank and Gaza, the result would basically be the preservation of the occupation. And it's not just something unique for Aaron Barak. It's also unique for most of the judges that are sitting in the Supreme Court. If we take a look on how the Supreme Court ruled in major issues that are related to the rights of Palestinians, we would see that the Supreme Court has been another chain in the authorities that not only led to the preservation of the occupation, but for its strengthening as well. Yes, we have, of course, here and there a few decisions that were in favor of Palestinians, but in general, we cannot say that it is the defender and it is the High Court of Justice. No, because also we're talking about a Supreme Court that is working within a legal system that has laws and constitution, basic laws that define the state of Israel as Jewish and democratic state. This duality is a constitutional value in the Israeli legal system. And it has been translated as well and has been used as well in the analysis of the Supreme Court. And I'll give you one example that relates to the protection of the political participation of Arab members of Arab political parties, Arab nominees for the Knesset, for the parliament. Since 2002, when the Basic Law Knesset was amended to enable the disqualification of persons or political parties that would call for the revocation of Israel as a Jewish and democratic state. Now, no one knew what is calling for revocation of Jewish and democratic state. And you, Dimitri, as a lawyer, would understand on the spot that this is something vague. And how can people know what, especially when you are living in an area, in a conflict area, where, of course, Palestinians cannot accept and surrender the fact that Israel is a Jewish state. So, of course, those who will, Arab political parties whose constituencies are the Palestinians would never accept that, and that's for sure. So since 2002, all Arab political parties have been disqualified by the Knesset whenever they would register for running the election. Each time Adalah, of course, jumps in order to represent them before the Israeli Supreme Court, because the procedures basically are: in the Knesset, you are disqualified, and then you go to the Supreme Court for confirmation or for an appeal. It depends on the issue. And the interpretation, basically also that was led by Aaron Barak, is that yes, this article of revoking the Jewishness of the state of Israel is a legitimate, it's a legitimate reason to disqualify, because yes, the state of Israel is the state of the Jewish people, and it therefore came and defined what are the core principles or core norms or principles of the Jewish state, which is you can't negate the law of return, you cannot negate the fact that the symbols are the Jewish symbols, the holidays are the Jewish holidays, and so on. There are a few principles to that. And it is through constitutional interpretation that was given by the Supreme Court that basically enabled later on the cancellation of the disqualification. But it's clear that you have a frame. If you go beyond that frame, and for example, when you want to call, or when 2 years ago, the Democratic Arab Party submitted a bill calling for a state for all its citizens, meaning Israel is the country, is the state for Jewish and Palestinian citizens and all other citizens. It was a basis to disqualify them before the Knesset, and it also reached the Supreme Court, arguing that calling for a state for all its citizens means revoking the supremacy of Jews in the state of Israel. So in order as well to defend them, this puts us as lawyers in a situation where we have to defend that calling what was done was not revoking, because it hasn't been an active, for example, active or a tangible activity by the political party, but it was just submitting a bill that even was not accepted. So all the time you have to be in the defense, because otherwise you will be excluded from the parliament, or from receiving benefits or budgets or whatever. So that's in general the framework that we are working in. And just as well to complete my answer, today we are working in a Supreme Court that includes judges that are settlers as well. We are aware as well that there are more conservative judges that are not keen in intervening in issues that are related to Palestinians. And it's being reflected more and more in the end result of a lot of petitions. And I think that it unfortunately will also be reflected in the end result of the petition against the Jewish nation state law.
Thank you very much, Sawsan. That's fascinating, and I feel your pain. So the next question I'd like to ask you, sorry if you just bear with me here. So this is from an anonymous attendee. Thank you so much for speaking to us today. You're extremely articulated and is much appreciated. One of the arguments used in pro-Israel spaces to justify the laws adopted following the Second Intifada, for example, to build a border fence and such, is that the suicide bombing stopped. What would you say to individuals who hold this view? What was the reason that the bombing stopped if not for this law? Or rather, what would you say would have been a better solution? I think you're muted.
I hope that I understood the question, but basically I didn't say that this law stopped the suicide bombings. I said that on the contrary, it had no connection to stopping or promoting or encouraging, because it's not even related to the ability of Palestinians to get in. What I said, and it's important as well for me to say it again, is that this law was allegedly enacted in order to stop suicide bombing, but it wasn't really meant for that, because it was meant to stop the demographic threat of Palestinians who wanted to enter Israel and stay and live with their families inside of Israel, knowing that the birth rate of Palestinians is higher than Jews. And knowing that, as I mentioned, in the last decade before that law, there were 195 or 200,000 applications to enter Israel. So they saw the demographic threat. And what I also mentioned is that based on the data that we got from the state when we asked them how many indictments, because if you say there were suicide bombers or people who attempted to harm the security of Israel, you would see people in jail. You would see indictments being submitted against Palestinians. But there were 7 people only in jail among those who allegedly misused their permit to enter Israel. Only 7 in jail and 0 indictments. So this just strengthens our argument that it's just for demographic threat. And why this is dangerous. Imagine that you are now living in Canada and you're saying no to French because you don't want to have a demographic, you don't want the French from France to imbalance the demography in Montreal or in Quebec. Applying it as a sweeping ban on all those who come from France without really enabling any individual check for who is really coming and who is not. Plus the fact that there was an argument that Israel has all the right to stop aliens from entering to its borders. But it's not about aliens, because we're talking about the same Palestinian people, but it's more about my right as Sawsan, as a Palestinian citizen of Israel, to have the right to live with my loved ones inside Haifa, where I live, inside of Israel. So, and I think that also the fact that they enabled the entry of Palestinians for the purpose of working inside of Israel also says a lot about their about the intentions of the law. Of course, if they would have said before the court that yes, the purpose is demography, they probably would have lost, because the Israeli Supreme Court, like any other Supreme Court, will not be able to rule in favor of demographic balance, but rather use security arguments as something that is more legitimate to dismiss a petition based on that.
Thank you, Sawsan. So the next question, I think probably best if I answer this one, because it has to do with Canadian government policy. and that is how has the Trudeau government responded to the ongoing annexation of Palestinian land? Well, the official position of the Trudeau government and the Canadian government for decades has been that the settlements and the annexation of East Jerusalem violate the Fourth Geneva Convention. And that position even extends to the Golan Heights, which under international law belong to Syria. But there's a world of difference, and that is true right up until the current time, between the government's official position and what it does in practice. In practice, it has encouraged and facilitated the ongoing annexation of Palestinian land in a variety of ways. It's done this by engaging in the arms trade and security cooperation with the Israeli government, by extending trade benefits, and I mentioned this at the outset, not only to businesses operating within the internationally recognized boundaries of Israel, but also to settlements in the West Bank. And this is right now, they won't even allow the Canadian Federal Food Inspection Agency to require settlement products to be labeled as coming from the settlements. They're allowed to be labeled as product of Israel. And of course, the Canadian government, and this is more true under the Trudeau government than any other previous government, including the Stephen Harper government, has been voting against the vast majority of resolutions at the United Nations that have been advanced in defense of Palestinian rights, and typically as part of a small minority of rogue nations, including typically the United States, Israel, Canada, and 4 or 5 tiny island states, to vote against these wildly popular resolutions. And those are just some of the ways in which the Trudeau government is in practice facilitating and acquiescing in the annexation of Palestinian land. So the next question comes from Scott. This is for you, Sawsan. How does the everyday resistance and protest by Palestinians affect the current discriminatory policies and laws by Israel?
Can you repeat that, please, Dimitri?
The everyday resistance and protest by Palestinians affect the current discriminatory policies and laws by Israel? Does it have any effect, and if so, how?
No, well, I don't think like there's a huge disparity between what we are able to do on the ground and what can happen. The fact that we can start with the legislator, the fact that the majority of the seats in the parliament also today are being seated and held by right-wing politicians and right-wing political party. The fact that even if since the first Knesset in 1949 was elected, there were few back then Arab members of Knesset. Today we have 15 in the joint list, but since 1949 until today, Arab political parties were elected to the parliament, to the Knesset, were never part of any coalition government. They never will be, and they never were welcome to be. So this means that they never had any effective role in terms of being able to affect the decisions, whether it is in the end result of voting on those discriminatory laws. Of course, the joint list, or generally the Arab political parties, are there and in most of the important votes, and they vote against. But when you're all the time in minority and you're never in the coalition with the government, and especially in the last 2 years where there were 3 national election cycles, where most of them basically failed to form a government because the Arabs had strengthened their power, and no one wanted to negotiate with them and sit with them in the coalition. So it's not that even if the Arabs want, they are never welcome, which of course we're not even I don't think that anyone will build upon it. So even if there will be demonstrations or any kinds of acts of resistance on the ground, it doesn't really affect the fact that more and more discriminatory laws are being enacted.
Thank you. So a question which is very interesting to me, again, as a litigator, coming from Sydney. If the nation state law is a basic law similar to a constitutional provision, on what legal basis can you challenge it in the Supreme Court?
There's this doctrine to challenge constitutional amendments called the unconstitutional constitutional amendments, or basically the misuse of constitutive power, which is also another doctrine to come and say that the majority, which is controlled as well, being held by the ethnic majority group, has misused its constitutive power in order to pass a constitution that is in favor of the majority group. These are basically the doctrines in law that enable the intervention or enable judicial review. They haven't been accepted by the Supreme Court of Israel yet, but this is what we are arguing for. And it basically means that if an amendment to a constitution is being passed, which is in contrast to the basic norms of the regime. Basic norms of the regime generally will be the values of democracy, basic constitutional human rights, etc. It's the core basis of what constitutes the norms and the values and the morality of the nation state or of humanity that you cannot contradict. And the question, the controversy is whether to apply this doctrine or not. Now, as I mentioned last week, the Attorney General defended in its response the Jewish state basic law and said that the Supreme Court cannot and does not have the right to intervene because these doctrines have not been adopted by the Supreme Court. And in addition, we're not talking about regular amendments to the Constitution. We're talking about a new Constitution that is setting the constitutional identity of the State of Israel, which in itself is also a dangerous argument.
Okay, so the next question comes from Dr. David Kattenberg, who I discussed earlier. It's a bit of a long question, but I'll try to simplify it. It's been a year since the United Nations Committee on the Elimination of Racial Discrimination cited, quote, the existence in the occupied Palestinian territory of two entirely separate legal systems and sets of institutions for Jewish communities and illegal settlements on the one hand, and Palestinian populations. The committee is appalled at the hermetic character of the separation of the two groups who live on the same territory but do not enjoy either equal use of lands or infrastructure, equal access to basic services. And this committee of the UN ruled in December of last year, a year ago, that it had jurisdiction over the case and tasked a subcommittee to decide on the admissibility of Palestine's communications, including determination that all available domestic remedies have been invoked and exhausted. And David says that since then, in that year, as far as he knows, there's been silence. And he wanted to know whether you know where this stands. Has there been any, are you familiar with this proceeding before the UN committee? And do you know whether there's been any meaningful progress in the last year?
Yes, I'm familiar, and we were part of the organization, civil society, that submitted the shadow reports to the third committee, and we were part of doing advocacy in order to reach such concluding observation. And we also held a few press conferences on that result last year. It basically was an important concluding observation, important narrative, because it's for the first time that the third committee in its concluding observation says that there's apartheid. This is basically what it said. There's apartheid, and they're acknowledging it, and they're saying that there are two separate systems that apply, basically each based on the ethnic group. And that nothing happened in terms that came out of the UN since then, because the UN, the third UN committee, issues its concluding observation each 4 years or even more. It depends on when the turn of the state that ratified the treaty is supposed to report on the state of human rights based on that treaty. And each state has a cycle of reporting every 4 years. So basically now we need to wait for the next cycle of reporting by the State of Israel, where we will submit our own shadow reports in order to contradict, and then there will be another concluding observation. So on that level, on that procedure, nothing has happened. But of course, we all know the attempt, the Trump plan was announced after that. The annexation plan were announced after that. And I think that what maybe led, I don't know, like we need to see what will happen in the US in order to see on the ground how these plans and policies will be implemented on the ground in order to strengthen and preserve the apartheid system in the West Bank. I can't hear you.
Okay, sorry. So apparently we have, unfortunately, time for only one more question. But I want to mention before I ask you that question, Sawsan, that Marie in the Q&A has asked for the postal address of Adalah in order to send you a donation. So perhaps you could type that into the chat. But here we go with the last question. And it's a recurring theme, the ICC and the questions. I'm sorry, we're not going to get to most of these questions. Some really good questions we just can't get to. But the recurring theme is the International Criminal Court. And one of the attendees, anonymous attendee, asks, does the ICC have the power to change these discriminatory laws? I think a lawyerly way to put it, does it have the jurisdiction to issue any kind of ruling in connection with these discriminatory laws and address the injustice arising from them? And if so, what can it do?
It doesn't have any jurisdiction to rule on issues that are related to inside of Israel, to these laws, but it can rule on war crimes or crimes against humanity if they will, be proven, especially in regards to the occupied territories in the West Bank and Gaza. And nowadays, we know that the issue of Palestine is before the ICC. It was brought by the prosecutor in order to consider or address and state whether Israel has committed the war crimes in the occupied territories. And Adalah, together with or like other organizations in the West Bank and Gaza, we submitted our arguments. We didn't submit it to the ICC, but we made it accessible and informed the prosecutor that there is a position by Adalah that basically does prove that war crimes have been conducted, but also proves, more importantly, that there is a jurisdiction for the ICC in order to examine these war crimes, especially with regards to the violations that are happening by Israel in Gaza. So there's a differentiation between what happens inside of Israel and what happens regarding the ICC, of course, and what happens in the occupied territories.
Thank you very much, Sawsan. It's a pleasure speaking with you today. Thank you to our hosts and to our wonderful guests. Just before, I'm going to certainly allow you to say a few concluding words, but I do want to point out that Scott Weinstein has typed into the chat the donation link for Adalah. hopefully there's a postal address in there where people can send. Is that the case? Will the donation link, Sawsan, provide a postal address where people can send perhaps a money order or something?
Yeah, it includes all the ways that donations are possible, including our address at the end of the page as well.
Okay, and just before I allow you to make some concluding words, I imagine Rafael will want to say a few things. Rafael, if you could just let people know where they can watch the recording of this. Someone in the Q&A has asked about whether a recording will be available.
Yes, the recording, thank you, Dimitri. A recording is available on our on the IJV Facebook page. So anybody can access it at any time. So I'll turn it back to you, Dimitri.
Thank you. So Sawsan, would you like to offer a few closing comments before we call it a day?
Well, I think that what I'm left to say is that I really appreciate the fact that all of you have came and had the patience to listen about all these things that I was presenting, but I think that it's just a nutshell, and things should, I really urge you to look into our website and get into depth on how things are being done. Despite all that, I think that we cannot lose hope. I am not losing hope as a human rights lawyer, because otherwise we will not be able to continue what we are doing. And I think that the fact that you in Canada, together with other groups as well, all over the place, the fact that you are doing these webinars and inviting me and my colleagues to talk about our work and the plight situation of Palestinians is a huge support and encouragement and emotional backup as well, I must say. So thank you all.
Thank you, everybody. Please keep healthy and safe. Take care.
Thank you.
Bye-bye.